Hello, everyone. Let's talk today about the U.S. Supreme Court's opinion in Florida versus Bostick. This is from 1991 during the Rehnquist Court, a court that is increasingly conservative and generally favors the state and the prosecution in cases involving criminal procedure, Fourth, Fifth, and Sixth Amendment. And so Justice O'Connor writes for the majority in this 6-3 decision. So the facts. There were two officers on a bus. They boarded it. They looked at the passengers. And then our defendant, the suspect, Mr. Bostick, they went over to, inspected his ticket and ID, and the ticket matched the ID. The officers explained that they were narcotics agents. They were on the lookout for illegal drugs, and they asked to search Bostick's luggage. They found contraband while doing so, and so the parties dispute whether consent was actually given, whether Bostick consented to this. The police did advise Bostick that he had the right to refuse consent, and the police officers never threatened Bostick with a gun. He was just seated in a bus. Bostick was arrested. He was charged with trafficking in cocaine. He moved to suppress the evidence of the cocaine on the grounds that his Fourth Amendment rights were violated. The trial court denied this motion. The Florida District Court of Appeals affirmed, but found the issue to be important, so they certified a question to the Florida Supreme Court. So Florida's Supreme Court then holds that Bostick had been seized because a reasonable passenger in his situation would not have felt free to leave the bus to avoid being questioned by police. So this makes its way up to the U.S. Supreme Court. Bostick argues to the court that his situation made him feel like he just had no choice but to comply. He was cramped on a bus, and he was seated with these two police officers just towering over him. Obviously, might seem a little intimidating. And the Florida Supreme Court, as the U.S. Supreme Court holds, was erroneous by focusing on this. There was a question of whether the encounter in a manner that happened to Bostick with his bus setting counts as a seizure under the Fourth Amendment. The Supreme Court ends up not answering this question. But they do believe that the Florida court, the lower court, applied the wrong standard. So the Florida courts are going to get a remand to evaluate the question under the correct legal standard. The crucial test is whether, when you take into account every circumstance surrounding the encounter, the police would have communicated to a reasonable person that he was not at liberty to ignore the police presence and go about his business. So it's a very holistic approach, a holistic analysis. Where an encounter takes place is only one factor. It's not everything. It's something to consider, but the Florida court erred by only considering this. Now, when a person is seated on a bus, the court says, and they have no desire to leave, the degree to which a reasonable person feels that they can freely leave is not an accurate measure of how coercive the encounter is. Bostick would not have felt free to leave even if the police weren't there, because he was seated on a bus. You can't just leave when you're on a bus that's moving. And also, it's important to emphasize, and this is not exclusively from Florida versus Bostick, but mere police questioning alone is not a seizure under the Fourth Amendment. Now, there's a dissent written by Justice Marshall, joined by Blackmun and Stevens. They don't agree with O'Connor that Bostick was free to end his encounter with the police. The sensation of constraint that he had as a passenger on the bus was not his fault, and the majority wrongly did not consider that enough. They think that this is another one of those wrongly decided pro-state criminal procedure decisions. Marshall obviously tends to be very pro-criminal defendant, so he is a fitting justice to author this dissent. So yeah, this is an important decision. The Fourth Amendment is really big in criminal procedure class for law students. It's also important if you're working as defense counsel or as a prosecutor to understand the rights of criminal defendants. And if you're trying to suppress evidence or you're trying to resist the defense's motion to suppress evidence, this is an important one to bring up, and it seems to come up in appellate briefs to the Supreme Court or to state Supreme Courts quite frequently. So yeah, that is Florida versus Bostick for you. Hopefully you will understand this and you find that it's helpful and that you get an A+ in your criminal procedure class. And as always, if you liked the video, if you found it helpful or insightful, please leave a like, comment, and subscribe. I really do appreciate it. Let's grow the channel. And as always, thank you, and I look forward to speaking to you in the next video.